Either the chair was very low or the desk was absurdly high. Susan knew that much. The desk dominated the stark room, a space that was functionally designed and devoid of personality. To Susan it felt strange, impersonal and intimidating. As she pondered how different this felt from her school, she was forced to pay attention as the three academics opposite her introduced themselves as Professor Firefly, Professor Spaulding and Dr. Quayle. Professor Spaulding, sat in the middle, began the conversation, or was it an inquisition, by asking Susan if she had studied law before. Not as a subject, no, she replied. But we've studied various acts of Parliament from the 19th century and from Nazi Germany in history classes, and we studied things like discrimination and human rights in religious study sessions, alongside religious rules like the Ten Commandments. We also looked at different approaches to ethics, different schools of philosophy. But I suppose that's something quite different, isn't it? Yes, responded Professor Firefly, clearly taken aback that he'd been asked a question. This course is concerned with the law of the land, the laws made by Parliament and interpreted by the courts, the law as found in the books. You will learn to think like a lawyer. But that's not different to what Susan has already studied, is it? Interrupted Dr. Quayle, much to Professor Firefly's dismay. All of the rules he mentioned are rules made by humans. This course just studies a particular set of rules. Rules are around us all the time, constantly shaping our behaviour. Yes, but they're not laws, Dr. Quayle. Obviously, the historical acts of Parliament might be, if they have not been repealed, but on this course and in this law school, we are only concerned with laws that are legally binding. Professor Firefly looked pleased with himself and looked to Susan as if he'd brought that part of the conversation to a close. Dr. Quayle disagreed. It depends how you define law, doesn't it? Who is to say that religious rules are not law? For adherents, they are binding. The same is made of school rules and other norms and expectations. The point is that humans create rules, norms, laws, call them what you want. Helen, I think you are missing the point, asserted Professor Firefly. We are concerned with the law. But the laws we are studying are human constructs, Professor Firefly, Quayle responded. They are not only the law, because we have decided upon a process for making things that we will call law. Who is to say that these laws are more important and worthy of study than other rules? Who is to say that they are different to laws that the state considers to be legally binding? Professor Firefly shook his head. I am not interested in these sorts of questions. They can be left to the philosophy department. As you said, and this is key, this course focuses on the law of the state, the legally binding and international law developed by international bodies as well, added Professor Spaulding. Well, of course, international law as well, Professor Firefly responded. And religious laws? Asked Dr. Quayle. No, not them. They are not legally binding, responded Professor Firefly abruptly and with some irritation. But surely there are questions as to international laws are always binding, responded Professor Spaulding. We spend time looking at that very question on this course. And sometimes religious laws can be made legally binding, in the sense they are recognised by courts. Indeed, any decision made by arbitration can be legally binding. Does that make it the law? Or is talk of the law just silly, a bit simplistic? I think we are getting a bit sidetracked, Professor Spaulding, replied a slightly flustered Professor Firefly. The point is that this course at this university law school, where I have taught for the last 23 years, is concerned with teaching the law of the land. We want our students to think like lawyers. Philosophical questions are all very interesting, but they have no place in the courtroom. Well, as someone who's also a practicing lawyer, I'm not sure I agree with that. Cases in court are all about all sorts of disputes, all sorts of questions, responded Professor Spaulding. No, they are all about legal questions, retorted Professor Firefly. Thinking like a lawyer requires you to know the law, to live and breathe it. You need to know the rules, the exceptions to the rules, the loopholes, defences, and so on. It is about knowledge, being able to synthesise the law into an argument. And it is about interpretation, knowing how to analyse and sometimes play around with the rules. Like a game of chess? Asked Dr. Quain. Professor Firefly was oblivious to her sarcasm and nodded at her dismissively. Dr. Quain continued. A game of chess, removed from reality. A game where chess pieces always remain the same. A game that cannot be changed. A great mental workout, but nothing more than that. Not something that can be moulded and shaped to help humanity. Is that your understanding of the law, Professor? I think you misunderstand me, Helen, snapped Professor Firefly, in which Susan detected was a rather condescending tone. Learning how to think like a lawyer makes you think about how the law can be improved. No synthesis of the law is complete without consideration or proposals for reform. But that's just tinkering within the system, is it not? Responded Dr. Quain. It doesn't question how useful or worthwhile the law is and whose values the laws protect. Yes, thinking like a lawyer is concerned with improvements, but only in terms of the machinery. Law reform within the system does not question the bigger questions. For that, you need to go outside the legal materials. You need to look at law within society. But that's not thinking like a lawyer. That's not preparing students for law in practice. That's not what we do here. Professor Firefly banged the desk with his hand as he spoke. I disagree. To study law is to study real life, responded Professor Spaulding. Each court case concerns a dispute between two real-life persons who consider the matter so important that they are going to the fuss and bother of going to court. Being a lawyer involves dealing with people, their disputes, their disagreements, and that is inevitably shaped by wider societal concerns. Indeed, whether they're able to protect their rights will depend upon their financial position and how much power they have, interrupted Dr. Quain. The law is not neutral. I didn't say that it was, said Professor Firefly. But the law is the object of our study. Obviously, we need to pay some attention to context, but we are training lawyers, not sociologists or philosophers. We are concerned with the legal dimension. We need to apply a critical approach, urged Dr. Quain, before he was interrupted. But we do, boomed Professor Firefly. Of course we do. We apply a critical approach to law. We analyse it. We critique it. We look at its shortcomings, its gaps, etc. We discuss how it can be improved and so on. Of course we apply a critical approach. But that's not what I mean by critical, interjected Dr. Quain. The problem with the word critical, I suppose, is that various different people mean various different things by it, pondered Professor Spaulding, as if he was beginning a lecture. It's become frequently used in the way that you're using it, Professor Firefly. Critical just means some sort of judgment. Being critical becomes a generic intellectual ability. To be critical is just to think. It just means to criticise, to find the flaws, to deconstruct. Susan and the two squabbling academics either side of Professor Spaulding thought there was a real risk now of Professor Spaulding delivering a lecture on the topic. They were right. Others mean something rather more specific when they talk of a critical approach. Professor Spaulding continued, warming to his theme. There have been a number of critical movements, often from a Marxist or left-wing perspective. These are critical in the sense they cause a disturbance by offering a different way of thinking, taking an alternative approach, often focusing on those people and groups that the law marginalises and seeing things from their perspective. Professor Firefly took advantage of a brief pause in Professor Spaulding's lecture to ask a question. So what do you mean by critical, Dr. Quain? He inquired. Well, a critical approach is one that exposes and addresses questions of power, C replied. For me, a critical approach is political, not in the sense that it takes a particular political stance, but in that it is directly concerned with questions of power. It can be contrasted with the usual approaches that accepts the status quo. These can be called functional approaches, Susan. A functionalist approach sees society as being a bit like the human body. Different parts of society work together like different organs, for society as a whole to operate, to function, like the human body functions. A functionalist approach sees society as being based on consensus. It's all about getting it to work, to function all together. It's all about getting the mechanics right. A critical approach, by contrast, sees society as being based on conflict. It notices that the systems work for some people, but not others. It highlights the biases and points to alternatives. It does not accept the status quo and looks to reconstruct as well as to deconstruct. But that's not thinking like a lawyer, retorted Professor Firefly. No, it's questioning like a citizen, Dr. Quain responded, and that's more important. That's all very good, but it's not the business of law schools, Professor Firefly responded. You want to mould students into accepting and perpetuating the system. Thinking like a lawyer is indoctrination, insisted Dr. Quain. Professor Firefly spat back. Thinking like a lawyer is the key to being a lawyer. You'd be furious if you were charged with a criminal offence and your lawyer didn't know what the law was or didn't know how to make legal arguments. But in practice, lawyers need to think creatively. Thinking outside the box is vital in order to help their client to advance justice, Professor Spaulding interrupted, and all present noted the risk of him resuming his lecture. But it's also important for them to be able to think inside the box, to play the system, to know the rules, but to question it. They need to be able to think critically in both of the ways that we've discussed. Professor Firefly looked as if he was about to interrupt Professor Spaulding, but noticed the time on the clock, and Professor Spaulding continued talking. Goodness me! Is that the time? Well, that's the end of your interview, Susan. Is there anything else you'd like to say? Briefly, please, insisted Professor Spaulding. It's almost time for tea. Susan was taken aback at being addressed. She'd enjoyed watching the debate so much that she'd forgotten that she was in the room with the squabbling professors. Thank you so much, Susan responded politely. I think, and this might be nonsense, so excuse me if it is, but is the answer actually that both approaches are needed? Law students need to think like lawyers and question like citizens. Both forms of education are needed. That's what being critical requires, being legally informed and being able to question and challenge. Susan was surprised by the silence that met her answer. As she got up to leave the room, she reflected that her initial judgment had been wrong. It was not that either the chair was very low or that the desk was absurdly high. It was rather that both the chair was low and the desk was high. Both positions were right and complementary.